And another delay in the Menendez brothers' bid for freedom after nearly 20 years in prison. The long-awaited resentencing hearing for Eric and Lyle Menendez getting pushed back again. The brothers now facing a May 9th hearing on whether they can be resentenced for the 1989 double murder of their parents. The Los Angeles District Attorney Nathan Hochman now pushing to have a comprehensive risk assessment on the brothers brought into evidence, putting things on pause. Back with us is trial attorney and legal analyst Misty Marris. Hello again, Misty. So the judge delayed the resentencing hearing over the risk assessment report into the brothers. What kind of document is a risk assessment report? Why would the brothers' defense team be pushing to limit access to that report?
Oh, Hannah, this was a dramatic day in court because the district attorney, right before the hearing, literally asked for a delay. The judge at first said no, and then after the hearing began to unfold, they argued about it, decided to push this back. So the comprehensive risk assessment report was requested by Gavin Newsom. Remember, the Menendez brothers are pursuing a path to freedom using this resentencing process, but also seeking clemency. So that's the first step in that process. And it's done by the parole board. And what the parole board does is analyze what's called static and dynamic factors. Static factors are things that do not change. The nature of the crime isn't going to change. The fact that it's a premeditated murder, all of that is not going to change. And then there's dynamic factors, which are, have they taken accountability? Are they remorseful? And most importantly, are they a threat to society? So all of that is going to be taken into consideration, including their behavior while behind bars. And we know they've had significant accomplishments, according to their defense team, while they've served their time and have lived, quote, meaningful lives, right? So all of that's going to be part of it. It also includes a psychological evaluation, which will assess from the parole board's perspective, are these individuals people that will be a threat if they were to be released? So all of that is going to be in the report. Now, here's the reason why you might want to keep it out, because from the defense perspective, we've heard this whole time that they have an impeccable record behind bars, that they have done so much while they were incarcerated. So why keep it out? Well, you have to remember what's in that report. It's going to include statements made by the Menendez brothers to parole officers. It might include statements they've made to the media. It's going to include results of medical evaluations, all things that could be hearsay, violations of their Sixth Amendment rights, or the right against self-incrimination. So what needs to happen needs to be exchanged to all the parties, reviewed May 9th, whether or not parts of it, all of it, or none of it are admissible under the re-sentencing component of this, a different process than the parole hearing.
The brothers' family says they plan to file a motion to recuse Los Angeles DA Nathan Hochman, saying he is biased against the brothers. Here's Hochman on Vargas just last night.
Nothing could be further from the truth. When the Menendez brothers fully accept responsibility for all their criminal conduct, deceit, lies, and cover-up, then we have said that the judge should reconsider at that point whether or not they've been truly rehabilitated, but we're not there yet.
Misty, you know the ins and outs of this case. How likely is it that a judge will rule in the family's favor and ultimately recuse Hochman?
I think it's unlikely, but it's important to note what the basis for the recusal motion is. It's not because Hochman disagrees with the position of Gascon or that Hochman disagrees with the defense. It's because he failed to disclose, according to the defense, this is their argument, he failed to disclose that he went to Beverly Hills High School and that he lived a mile away from the crime scene. So he was in that area and kind of intimately connected to this, this was a huge story in a way by being in that locale. It was a national story, but locally, it was even bigger. So they say, from the defense perspective, that's bias, and it's based on that failure to disclose, not necessarily Hochman's assessment of the case at this time. Now, they also say he violated Marsy's law. Marsy's law is basically the victim's advocacy rules in California. Because number one, that they showed this crime scene photo during one of the proceedings without warning to the family. The judge kind of dismissed that argument. But the other argument is that a victim's advocate was never assigned to the Menendez family. Now, it's a unique case. The family is actually supporters of the defense. That's not the typical situation, but a victim's advocate was never assigned, and that's required under the law. And they say that that emphasizes the bias that Hochman has. So again, I think it's unlikely to be successful because it's such a high standard for recusal. There has to be some kind of very tangible bias. but I don't blame the defense for raising those arguments given the circumstances of the case.
Misty, I have a minute left, but I want to get this in. The hearing for clemency from Newsom, Governor Newsom, is now scheduled for June. How could what happens in resentencing factor into the clemency decision?
So it's two completely different processes. The clemency decision, it's going to be based on that comprehensive risk assessment report, the recommendation of the parole board, but ultimately it's up to the governor. He has a lot of autonomy on what to do. So resentencing hearing, if they're successful during the resentencing hearing, meaning the court says they can either be eligible for parole or immediate release, the judge can say whatever, the judge has total discretion. There might not be a necessity for the clemency hearing. However, if the judge were to say, listen, the Menendez brothers should be, their sentence should stand, then clemency becomes their most likely route to success. But that comprehensive risk assessment, Anna, we know that could be part of both cases.
Really good job explaining this case. It's very complicated. Misty Marris, thank you again.
Thanks, Anna.